Hello and welcome again. To expand a little bit on diversity management and equal opportunity, we're going to take a look at equal opportunity and HR management. Our objectives for this lesson is to examine the reasons for EEOC legislation and the record keeping that must be completed by HR. We're going to learn what a bona fide occupational qualification is, take a look at the insight into the problems of sexual harassment, immigration reform, and other discrimination practices and how they affect HR. And we're going to define what affirmative action is and why having a diverse workforce is important. So let's start off with what is EEO? It's the treatment of individuals in all aspects of employment, in the hiring, the promotion, the training, etc., in a fair and non-biased manner. If you look at the chart here, you can see prohibited discriminatory employment practices. And it says here it is illegal to discriminate in the aspect of employment, or discriminatory practices under these laws also include. I'll leave this chart up for you for a moment so you can digest it. And again, if you'd like to read it in depth, you may pause this presentation to do so. Adverse impact and employee discrimination. Disparate treatment is the intentional discrimination that occurs when people are purposely not given the same hiring, promotion, or membership opportunities due to their race, color, creed, sex, age, ethnic group, etc. The impact is below. Unintentional discrimination occurs when members of a race are intentionally harmed or disadvantaged because they are hired, promoted, or trained at substantially lower rates than others. And there's also what's called the 4/5 rule, or 80% rule, used to determine if there's been a case of adverse impact. The Equal Pay Act of 1963 states that it is illegal to discriminate against people in terms of pay, benefits, and pension based on their gender when doing the same work as other members in a different gender. Civil Rights Act of 1964 states discrimination is prohibited on the basis of race, color, religion, sex, or national origin, but notice that it doesn't say age. Most major federal employment laws are listed right here, and again, I invite you to read these. They're all listed for you. We cover several of them. And I will leave this slide here for a couple of moments for you to view. And again, you may also pause it if you'd like to read them all in depth. What are protected classes? These are individuals of a minority race, women, older people, and those with disabilities who are covered by federal laws on EEO, those that are most affected by unfair employment practices. A bona fide occupational qualification is a suitable defense against a discrimination charge only when age, religion, sex, or national origin is an actual qualification for performing that job. Title VII of the Civil Rights Act prohibits discrimination based on religion in employment decisions, though it permits employer exemptions. It defines religion to include all aspects of religious observance and practice, as well as their belief. It does not require employers to grant complete religious freedom in employment situations, and it requires that employers make a reasonable accommodation at minimum cost without incurring undue hardship in the conduct of the business. Managers or supervisors have to accommodate employees' religion in the specific areas of holidays and observations in their scheduling, personal appearance, wearing a beard, a veil, or a turban, and religious conduct on the job, missionary work among other employees. The Age Discrimination Employment Act of 1967 prohibits employers from discriminating against employees and applicants that are older than 40 years old in any employment area. Do you think this is ironclad? I do not. I believe they have ways around it. But should you discriminate because of age? No. Some of your older people have the most experience and knowledge and should be cherished rather than pushed out the door. A wonderful program in Australia. The government provides $10,000 to businesses for every employee that is older eligible to work. And I think the United States should adopt such a plan too to encourage hiring the older workers. Excluding older workers from important work activities, making negative changes in the performance evaluation of older employees, denying older employees job-related education, career development, or promotional opportunities, selecting younger applicants over older, more qualified candidates, pressuring older employees into taking an early retirement, reducing the job duties and responsibilities of older employees. All of these are against the law. And certainly terminating older employees through downsizing is a big no-no. We also have Pregnancy Discrimination Act of 1978. It's an amendment to the Civil Rights Act of 1964 stating that pregnancy is a disability and that pregnant employees must be treated on an equal basis with employees having other medical conditions. The American Disabilities Act of 1990 prohibits employers from discriminating against employees with physical and mental disabilities or the chronically ill. The act requires employers to make a reasonable accommodation for disabled people. Reasonable accommodation is an attempt by the employers to adjust, without undue hardship, the working conditions or schedules of employees with disabilities or religious preferences. The ADA does not cover homosexuality or bisexuality, gender identity disorders not resulting from physical impairment or other sexual behavior disorders. It doesn't cover compulsive gambling, kleptomania, or pyromania, psychoactive substance use disorders resulting from the current use of illegal drugs, or the current illegal use of drugs, period. It doesn't cover infectious or communicable diseases of public health significance applied to food handling jobs only and excluding. And here again we have a chart, the American with Disabilities Act of 1990. These are suggestions for an accessible workplace, things that you should do to make your workplace more accessible. And again, I'll leave this for a moment. Feel free to pause to read it in depth. The EEO rules applicable to federal contractors and agencies are as below. Vocational Rehabilitation Act, Executive Order 11478. These are all also federal laws, and I recommend you get to know these if you are going to be an HR person. Sexual harassment. Basically, it's a form of discrimination in which unwelcome and unwanted sexual advances, requests for sexual favors, or other physical, verbal conduct of a sexual nature occurring while one is doing their job. Quid pro quo, something for something. Employment outcomes or keeping one's job dependent on whether an individual submits to sexual harassment. Obviously a big no-no. And the hostile work environment, unwelcome and demeaning sexually related behavior, creates an intimidating and offensive work environment, not only to the person being harassed, but to other employees who feel the situation and environment is uncomfortable. So, again, we already said sexual harassment is unwelcome advances, requests for sexual favors, or any physical, verbal conduct of a sexual nature. An employer is guilty of sexual harassment when the employer knew or should have known about the unlawful conduct and failed to remedy it, or the employer allows non-employees, like customer salespeople, to sexually harass employees. What does quid pro quo harassment mean? It means it occurs when submission to or rejection of sexual conduct is used as a basement for employment decisions, like, I will give you this promotion if you go out with me tonight, or if you agree to see me on the side, I'll make sure that you get a raise. Those kind of things are big no-nos. Involves a tangible or economic consequence, such as demotion or loss of pay or loss of job. Hostile environment occurs when unwelcome sexual conduct has the purpose or effect of unreasonably interfering with job performance or creating an intimidating, hostile, or offensive work environment. Dirty jokes, vulgar slang, nude pictures, swearing, and personal ridicule and insult constitute sexual harassment whenever an employee finds them offensive. The courts use a reasonable person test for hostile environment rulings. Title VII of the Civil Rights Act of 1964 lists sex, gender, as a protected class. Sexual orientation is not a valid defense against discrimination. Gender applies to one's sex at the time of birth and not to one's sexual preference or orientation. No federal laws bar discrimination based on sexual orientation or transgender and transsexual individuals. Companies in support of the diversity workplace initiatives are fostering gay-friendly workplaces. Most companies in the Fortune 500 now offer health benefits to same-sex couples. So the Immigration Reform and Control Act of 1986, what was the purpose of it? Employers covered by the law are prohibited from knowingly hiring or retaining unauthorized aliens on the job. People who do not have a green card, for instance. Employers with 4 or more employees are prohibited from discriminating in hiring or termination decisions based on natural origin or citizenship, however. The U.S. Department of Justice lists 5 actions that employers must take to comply with the law. Having employees fill out their part of the I-9 form. Checking their documents establishing an employee's identity and their eligibility to work in the USA. Complete the employer section of the Form I-9, retain the Form I-9 for at least 3 years, and present an I-9 form for inspection to any Immigration and Naturalization Service officer or to a Department of Labor officer upon request. Weight discrimination. A couple years back, there was a big lawsuit in the news about Hooters, where one lady who started gaining weight because she was pregnant was let go because of her weight gain. Another young employee was not hired because her breast size was not large enough. These are not bona fide occupational disqualifications. Attractiveness discrimination, physical characteristics, and personal appearance cannot be discriminated against for that. Caregivers discrimination, a single parent with a child with a disability or single parents cannot be discriminated against. The Uniform Guidelines on Employee Selection Procedure is a procedural document published in the Federal Register to assist employees in complying with federal regulations against discriminatory actions. It applies to employee selection procedures in the area of hiring, retention, promotion, transfer, demotion, dismissal, and referral. The use of any selection procedure which has an adverse impact on the hiring, promotion, or other employment or membership opportunities of members of any race, sex, or ethnic group will be considered to be discriminatory and inconsistent with these guidelines unless the procedure has been validated in accordance with these guidelines or certain other provisions are satisfied. So, that is a direct quote from the Uniform Guideline on Employee Selection. The validity test is a requirement that when using a test or other selection instrument to choose individuals for employment, the employers must be able to prove that the selection instrument bears a direct relationship to the job success and not of a discriminatory nature. Proof of validity is established through validation studies that show the job relatedness or lack thereof for the selection instrument under study. Adverse impact is the rejection of a significantly higher percentage of a protected class for employment, placement, or promotion when compared with a non-protected class. Possibly the unintentional result of an innocent act, yet the outcome is still discriminatory. The 4/5 rule, we talked about that a moment ago. It's a rule of thumb followed by the EEOC in determining adverse impact for use in enforcement proceedings. According to the Uniform Guidelines, a selection program has an adverse impact when the selection rate for any racial, ethnic, or sex class is less than 4/5 or 80% of the rate of the class with the highest selection rate. The 4/5 rule is not a legal definition of discrimination, but rather it's used to monitor severe discrimination practices. Disparate treatment. Disparate treatment is an employer's intentional unequal treatment or evaluation by different standards of protected class members. It's a situation in which protected class members receive unequal treatment or are evaluated by different standards than the rest of the workforce. The workforce utilization analysis is a process of classifying protected class members by number and by the type of job they hold within the organization. The composition of the EEOC, 5 members and a general counsel are appointed by the President and confirmed by the Senate. Members serve staggered 5-year terms, no more than 3 commission members from the same political party, and general counsel serves a 4-year term. The purpose is to formulate equal opportunity and policy and approving all litigation involved in maintaining equal employment opportunity throughout the country. So if you file a charge for employment discrimination, here are the steps and the process that takes place. And I will leave this chart up here for a few minutes for you to look at. And again, if you'd like to look at it further or in depth, you may pause the presentation. Retaliation. Managers and supervisors must not retaliate against individuals who invoke their legal right to file charges or to support other employees during an EEOC proceeding. Title VII of the Civil Rights Act states that an employer may not discriminate against any of its employees because the employee has opposed any unlawful employment practice or because the employee has made a charge, testified, assisted, or participated in any manner in an investigation, proceedings, or a hearing under this act. Thus, whistleblowers are protected. So let's talk about preventing discrimination charges. The foundation to prevent any form of discrimination is having a good in-house comprehensive EEO policy. Employers that do not have an EEO policy are vulnerable. A comprehensive EEO training program for managers and supervisors will include prohibitions covered in the various EEO statutes, guidance on how to respond to complaints of discrimination, any other procedures for investigating complaints, and suggestions for remedying any inappropriate behavior. Affirmative action is a policy that goes beyond equal employment opportunity by requiring organizations to comply with the law and correct any past discriminatory practices by increasing the numbers of minorities and women in specific positions in the company. Reverse discrimination, again, the act of giving preference to members of protected classes to the extent that unprotected individuals believe they're being discriminated against now. Challenges to an affirmative action program. A has not improved protected groups' employment. Individuals hired under AA feel prejudiced or prejudged as inferior performance and therefore viewed as tokens. These programs have failed in assimilating protected classes into the workplace. Preferences showed toward one protected class may create conflicts between other minority groups. And the bottom line, try to incorporate diversity within the workplace. However, it should always be the best person qualified for the job, regardless of the diversity, and never hire because they are diverse. So be sure to see our sections on diversity management. There's a lot there, a lot of laws regarding it, and we welcome your visit to all these sections. Thank you for viewing with us today. Have a great day.